Hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Good morning, everyone. Welcome to the term of court today on Zoom. Good morning, Judge Federico and Judge Murphy. We've got 6 cases on our docket today, and we will be hearing oral argument in 4 of those cases, and we'll take 2 on the briefs. So we'll call our first case, case number 24-6244, United States versus Velazquez Hernandez. Counsel?
Judge, I've just asked him to start his camera.
Okay. All right, Mr. Lunn, we can see you. You can proceed when you're ready.
Can you hear me okay now?
Yes, we can.
Good, thank you. I'm sorry. May it please the court. Good morning. My name is Bill Lunn. I represent Sergio Velazquez Hernandez. This case involves the application of the newly revised Federal Rule of Criminal Procedure 106, which is known as the Rule of Completeness. The advisory committee notes seem as if they're almost written for this case. They state that the rule of completeness cannot fulfill its function if a party creates a misimpression and can then object on hearsay grounds and exclude the statements.
Counsel, but before you get too far down the road of the merits here, what is our standard of review? Do you agree now that you are on plain error review?
No.
What is your position? No. Why not?
No, because I think the Beach case applies in this case. That is a situation where all you have to do is to make the court aware of the argument that has been made, and that is what was done in this case. There's no requirement that you cite verbally the rule of completeness. There's no requirement that you state the rule 106. And we have cases, the Cates case and the Holquin case, which is a Supreme Court case, that state that all you have to do is to put the court on notice. And that was done.
What did you say about Rule 106? Did you specifically invoke Rule 106 to the district court?
No, but neither did the defense attorney in the Beach aircraft case either. So, and the court in 1988, the Supreme Court found that the court had been put on notice of the claim that was being made. And in fact, in this case, the court, when at the instruction conference, as the defense attorney was reiterating the fact that he should be able to get this information in, the court said that your argument is preserved. I think that the court unquestionably was on notice.
So are you asking us, in Rule 103, there is some wiggle room to assume that the court understood your objection if it's the substance is apparent from context. And what in this record should counsel us to conclude that the court understood that you were making this quite precise Rule 106 argument in the way that you're advancing it now.
The entire argument had to do with his concern about the welfare of his mother. And that was the reason why he had to take the drugs from Los Angeles to Little Rock. And if he didn't do that for this drug lord that was in Mexico, the Mexican drug lord was going to have his mother killed. So it's a relevant issue that his state of mind, which is extremely well shown in particularly the interview video, where he breaks down.
Well, wait a minute. What did you argue to the district court was the misleading things that needed to be straightened out to have this matter admitted? What did you tell the district court?
Well, the attorney told the district court that this was his story. This was his. Wouldn't you agree that the rule of completeness requires that it be necessary to fully disclose what was going on in light of misleading things from either the context or what the prosecution had put into evidence? Oh, absolutely.
Don't you concede that's necessary under 106?
Yeah, yes, and in fact, the advisory notes.
Wait a minute. I don't want you to go there. I want you to tell me, what did you tell the district court in that regard? What was it that needed to be clarified that wasn't already clear?
Well, he said that this was the most important, powerful piece of evidence that there was in this entire case. And it was, unquestionably. He breaks down 8 times.
Well, all the information that was before the court indicated that he was nervous and that he was upset. All that was already before the court, wasn't it?
He was upset because they were going to kill his mother. And that came out during the course of the trial. But the state of mind, which is what advisory notes now allow you to get into.
Okay, if the information had been included, would there be a statement that I'm so upset because of my mother?
That was covered during the course of his direct examination by the defense attorney.
Exactly, and you didn't need anything more to do that, correct?
I don't think so. I think what was at issue here was his state of mind and why he was bringing the drugs from Los Angeles. He was bringing the drugs from Los Angeles because he was being coerced by the drug lord who said that he was going to kill his mother. And his state of mind, because he broke down emotionally 8 times during that interview, was exclusively based on his statements that he was worried about the welfare of his mother. It was highly relevant to a duress defense.
Do we need to address your argument as to each piece of evidence, right? We have to look at it separately for the post-arrest interview and then separately for the dash cam. Is that fair?
They're both almost virtually the same. The police officers pretty much have the same explanation. The officer the patrol officer says that he can't tell whether it was about his mother. He really couldn't understand. He was crying. It was difficult to understand. And Officer Snyder during the interview says he cried through the whole thing, whether we were talking about his mother or whether we were talking about narcotics. And he said that he could not say whether he was crying because he had been caught or about harm to his mother. But when you then play these tapes, in the first instance, there's one case which happens within minutes of the time that the patrol officer gets into his car, and he says, "My mom, they're going to kill my mom." So that's the first instance. And then the second instance, of course, are the 8 times where he literally breaks down, and every single time, the reason why he breaks down is that he makes a comment about concern over the welfare of his mother. So when the officers are on the stand saying, well, gee, we just really didn't quite know what this was all about, there's no question when you watch these two tapes, and I hope that you've had the opportunity to do that, that the reason why his state of mind, which the advisory notes say is something that's relevant in the rule of completeness analysis, his state of mind was that the reason why he had to take the drugs was because they were going to kill his mother if he didn't do that. And
does it matter for purposes of our assessment of your 106 argument that the government didn't play the post-arrest interview? Any portion of it?
I'm sorry, is it relevant?
Does it matter for purposes of how we think about Rule 106 here that the government didn't play any portion of the post-arrest interview? They presented testimony, but they didn't play the video. How should we be thinking about that?
No, I think it is highly relevant because, again, it shows his state of mind. His state of mind is one of extreme agitation, which is based on his fear that now that this situation has arisen with the stop, that the drug lord is now going to kill his mother. And that comes across loud and clear. And for purposes of putting on the duress defense, it was absolutely critical. I mean, you look at the Moore case, our adversarial system depends on opposing parties offering evidence that will strengthen their respective positions and damage that of their opponent. And that's exactly what we have here. The government did not want this evidence whatsoever. And again, the advisory notes state, and they're arguing that it shouldn't be admitted because it's hearsay. The advisory notes state that the party creating the distortion forfeits the right to object based on the grounds of hearsay. They forfeit it. That is what the judge should have responded instead of saying, oh, you're right, that was hearsay. In the court's ruling, which he does 3 times during the course of this trial, the court decides that these other parts of the interview and the traffic stop can't be shown to the jurors. His ruling is based on the fact that it's hearsay.
But that's because, Mr. Lamy, it certainly seems that the district court was reasoning in response to the absence of your 106 argument. I mean, what you had presented to the district court was that you identified the evidence you wanted in, you explained why it was really important. You said this is important evidence, this is his statement, but you did not present the district court with the basis for your, with the same basis of the argument that you're making now on appeal.
Well, his comments at the time of Snyder's, the defense attorney's comments at the time of Snyder's, is that it's when he says it's hearsay, the defense counsel says it's an important piece of evidence. It's the first time he tells his story. And that's the reason why it was important. It provides for an explanation of why he's bringing drugs. I mean, for instance, they don't even have...
Can I ask about the Beech aircraft again? Because it seems to me your argument relies heavily upon that case and the idea that you didn't need to tell the district court that you were offering this evidence under the rule of completeness or 106 because it should have been obvious. But in Beech aircraft, I mean, the issue was the whole trial was about whether or not this crash had occurred due to aircraft malfunction or pilot error. And the witness testimonies, the examination seemed to infer that the witness's opinion was that it was pilot error, when really it was misleading. And it was obviously misleading because his whole letter was about aircraft malfunction. So that seems somewhat categorically different. This goes to Judge Murphy's question about what's misleading about the scenario here, because the story that he was transporting the drugs to save his mother, that came out at trial.
Well, but it didn't come out in terms of what the defendant's state of mind was, which was best exemplified by the recordings. But
the officer testified he was crying almost through the entire interview.
Well, that may be, but just simply to say he was crying without saying why he was crying, why he broke down so many times. And every single time he broke down, he made a statement about the welfare of his mother. And
but I thought that you asked the district court at one point to play the video without the audio.
Yes, that's right. We did do that. And the court wouldn't do that either because the court said that that was hearsay, which was not consistent with the advisory notes, which state that the rule actually has been expanded. It covers all statements, including statements made through conduct. So that was another rule of error that the district court made. And when the court makes an error of law, that is by definition an abuse of discretion. And that's what happened in this case. The court consistently, 3 times, actually 4 if you include the statement about the conduct, 4 times, the court did not allow this in because of hearsay. And the government had been allowed to basically manipulate the defendant's duress defense by saying that it just really wasn't quite clear what he was crying about. When if these items had been presented in full, or even if they had been taken out in snippets in the same way that the government did. The government had 20 minutes of snippets to show exactly what the reason was why the defendant was crying. Then under those circumstances, the defendant's duress defense would have been fortified substantially. It certainly calls into question the validity of the verdict in this case when the jury never saw any of these interviews. I'd like to reserve the remainder of my time.
Thank you, Mr. Lunn. Mr. Krieger?
May it please the court, Stephen Krieger on behalf of the United States. The district court did not abuse its discretion, much less plainly err, when it failed to admit defendants' exhibits 1 and 2 under the rule of completeness. Mr. Lunn and the court have talked a great deal about the standard of review, and I would submit that it is for plain error. Looking at Beach first, I think Judge Federico gave a very good summary of Beach Aircraft. Ultimately, 106 wasn't an issue in Beach Aircraft, and the court said that it wasn't an issue. But in the footnote where it was explaining preservation, it noted that the defendant or counsel who was offering it was interrupted first by opposing counsel and then by the court. What the proposing counsel had said was, talking about the witness, he had been asked to answer every single question Mr. Toothman, the opposing counsel, had respecting, at which point he was cut off by the court. The Supreme Court explained that that was enough, given the context, to put the judge on notice that he was raising a completeness argument. Here, on the other hand, the first attempt to admit Defense Exhibit 1, which was the police station interview, happened at page 29 and 30 of Volume 3 of the Record on Appeal, before any evidence was admitted, before any evidence was offered. The rationale that was given was because, as has been said, it was an important piece of evidence. It was the first time he told his story. But Rule 106 doesn't talk about the importance of the evidence or the first time telling one's story. Instead, it says that evidence may be offered, or the adverse party may require the introduction at the time that the other evidence is offered. So pre-trial, before any evidence is offered, Rule 106 simply has no application. I would also point out that based on his story and based on what both the court and—
I'm sorry, Mr. Hart, can I interrupt you for a second?
Of course.
Can you say more about your position that Rule 106 doesn't even apply here, separate from that its requirements may not be satisfied? I wasn't understanding exactly where you were getting at.
Okay. I'm talking about at the very beginning. So when Mr. Hernandez first sought to admit Defendant's Exhibit 1, it was before trial. So no evidence had been submitted by the government. Nothing about the police station interview had been discussed. And so Rule 106 says, and to quote, if a party introduces all or part of a statement, an adverse party may require the introduction at the time that the opposing party introduces a portion of the statement, other parts or any other statement that in fairness ought to be considered at the same time. And so since no evidence had been admitted or offered at pages 29 and 30, the attempt to offer Defendant's Exhibit 1 at that time could not be based on Rule 106. I'll jump ahead to where he sought to admit Defendant's Exhibit 1 the second time at page 167 to 68. And when the district court asked if there was any additional rationale, and this is happening at the very end of trial, if there was any additional rationale for admitting that evidence, hearkening back to pages 29 and 30, pre-trial, the defendant said no, there was no additional rationale. So I'd submit Defendant's Exhibit 1 plainly falls outside of being offered for Rule 106.
Does it matter this is the same question that I asked Mr. Lund, does it matter for purposes of our review under Rule 106 that the government never offered any portion of the video? In other words, our cases talk about completing portions. The rule certainly seems broader than that, but I wanted to know what the government's position was on my question.
I think, and I'm not sure I've seen any case, at least where this court's addressed it. I think based on the plain text of the rule, if the government had asked, for example, if the government had asked in a murder case, to use the example from the application or from the committee's notes, is this your gun? And the defendant had said, yes, that's my gun, but I sold it 6 months ago. And the government testified, had a witness who testified. What did the defendant say? He said, I sold, or it was my gun. I didn't ask anything else. If the defendant wanted to play the statement rather than ask the witness, I think under Rule 106, he could probably play the statement in light of the portion, the clause, or any other statement. That being said, I think it also is within the broad discretion of the district court to say they admitted it through testimony, you have to admit it through testimony. As this court explained in Harry, the district court under Rule 106 has enormous discretion on how to apply the rule. So does it have to be in the same format? This court has never said. And I think it would be within the district court's discretion at that point.
Mr. Krager, can I ask you, is the government's position that we should be reviewing this on a plain error analysis, or that there's appellate waiver here because the appellant did not argue for plain error in their opening brief, that it's waived and we shouldn't be considering this argument at all?
Your Honor, we did argue for waiver, and I'm happy to stand by that. I understand that this court, different panels of this court and just different judges have taken positions that criminal defendants can raise plain error in their reply brief and argue it for it there, and it's no longer considered waived. Mr. Lund, with due respect, is a very distinguished attorney. He had the opportunity to argue it in his opening brief, and he chose not to do it. We would stand by waiver, but this court ultimately doesn't have to reach it if it chooses not to, because it could say it's not plain error.
The government makes an argument in your brief about under Rule 403, and if we're under the plain error standard of review framework, what are we supposed to do with your Rule 403 argument?
Your Honor, and I understand in our brief we tied it more towards the first prong. I think it probably settles better in the third prong of plain error. Third prong asking whether there's, but for the error, is there a reasonable likelihood of a different result? And 403, applying it under the third prong, would ask, is there a reasonable likelihood that the district court would have admitted the evidence, notwithstanding Rule 403? And I would submit that Mr. Hernandez has not shown that there's a reasonable likelihood, in large part because given all of the facts that were admitted, the undisputed fact that he was crying, that he was upset, to use the words that his attorney used in cross-examining the Sergeant Seal and Detective Snyder, he was, quote, very emotional, close quote. The only real purpose of admitting video of him crying is to influence the emotions of the jury, which is the type of unfair prejudice Rule 403 is designed to
Are you,
protect things.
I think I agree with you that it's a better fit under the third prong than the first, but still, is the government aware of any cases where we've done an analysis of the reasonable probability under the third prong by reference to something as discretionary as a determination like Rule 403? I mean, is that just are you aware of any case where that crosswalk has been made?
To be perfectly honest, I'm not aware of any case, Your Honor. And I will say that's not where I would necessarily have to hang my head on or hang my argument on the third prong. I think that's one way of getting to the third prong. I think the second way of getting to the third prong is to look what this court did in Pierce, what the Second Circuit did in Thiam, the Seventh Circuit did in Haddad, and the Ninth Circuit did in Lopez, which explained in each of those cases that any error, and many of those were preserved errors, any error was harmless because the information was presented to the jury through witness testimony. And here, pages 69 to 72, you had Sergeant Seal testifying that Mr. Hernandez was crying during the trip back and clarified upon cross-examination that he said he was, quote, in fear of that his mother, who is in Mexico, would be harmed. And you had page 92 where Detective Snyder, in responding to cross-examination, testified that Mr. Hernandez was emotional during the interview. He was asked that and he said yes, and then inserted that he was several times. He confirmed that he was crying and that he cried through the entire
Mr. Krager, isn't some aspect of completeness the proposition that an actual video of what was happening is much better than an oral recitation from an adverse witness about what was happening? And for completeness, there ought to be some thumb on the scale in favor of the video?
Your Honor, I push back and respectfully no. I don't think, at least Rule 106 and the Rule of Completeness, that's not the issue. There might be an argument about the best evidence rule, that video being the better evidence.
Wait a minute. No, I mean, the rule says that in fairness ought to be considered at the same time. Now, if a video of what actually happened is proposed, isn't that a lot better than a witness's recitation and comes within that phraseology of 106?
So 2 points in response, Your Honor. First, the fairness that Rule 106 talks about, as this court has explained, has to do with correction of misimpressions or some sort of misstatement, something along those lines, not that there's better or more compelling evidence. And we can see this, turning to the second point, in this court's decision in Williston, where the government admitted admitted portions of the video, 24 minutes worth of clips from a 90-minute interview. And the defendant sought to admit clips from the same interview, arguing that they would have provided a more complete picture of what happened and shined a different light.
Wait a minute, that's different. That's selection of video. I'm asking if the video is available and it's kept out and all you have is just a cold recitation of the record from an adverse witness about what happened. It isn't, in fairness, the video should be allowed in?
Well, and I think if I can finish Williston, talking about Williston, that answers your question. So in Williston, the district court did allow the defendant to ask certain questions on cross-examination to get some of the information that he sought to be admitted. He didn't allow him to play clips, but he was allowed to ask questions. And in Williston, the defendant argued that that violated the rule of completeness, which I think is the very situation you're positing. And this court said that the approach offered by the defendant didn't satisfy Rule 106's requirements that the additional statements be offered to clarify or explain misleading evidence admitted by the other party. So,
but in that case, the government offered video and the defendant wanted more portions of video. And
Correct.
I think Judge Murphy's question, if I'm understanding it correctly, is here we have testimony and the defense wants video. And isn't, in fairness, that video properly within the scope of exactly what Rule 106 contemplates?
Well, I do think that a court could exercise the very broad discretion in applying the vague fairness test to allow that. I mean, I'm not saying it would be an abuse of discretion to allow that, but it is, as this court explained in Harry, it is very broad discretion that the court has. And this is why I point back to Williston, because yes, the government played videos, and you would think if the government played videos, then fairness at its heart would probably allow the defendant to play videos rather than to elicit, at least based on the concerns that have been expressed, the cold testimony. But here, the government only admitted cold testimony on its behalf. The fairness, it would be even less to say that the defendant can also only offer testimony. One other thing I would point to, the entire reasoning, at least that Mr. Lund has suggested, that these videos should have come in fairness, is so the jury could see that he was crying about his mother. But as Detective Snyder explained, it would be speculation to know what he was crying about, because the only person who can truly explain that is the defendant. And at pages 125, 126, 133, and 140 of the record on volume 3 of the record on appeal, the defendant did just that. He explained it. He explained that he was worried about his mother, that he was shaken up because of his mother, that he was schizophrenic because what could happen to his mother, that he was already panicking and completely nervous about what was happening to his mother. In addition to the fact that and I see that I'm running out of time, so unless the court has any further questions, I'd ask that you affirm the judgment and sentence below. Thank you.
Thank you, counsel. Does Mr. Lund have any time remaining? Yeah.
No, he doesn't.
Okay. Thank you, counsel, for your helpful arguments. We will submit the case. All right, we will call our next case this morning. Case number 24-1438, Zynex Medical versus Coyote Stone. Okay, looks like we've got our counsel here. All right, Mr. Rylander, you may proceed when you're ready.
Yes, Your Honor. May it please the court. I'm Kurt Rylander on behalf of Coyote Stone, LLC. I'd like to reserve 2 minutes of my time for rebuttal.
Okay.
Your Honors, it is the position of Coyote Stone that the order of the magistrate in the district court should be reversed with instructions to dismiss the petition. There are a lot of meaty issues in this briefing, in this case, but we think the most straightforward path to reversal is that Zynex admitted that the targeted witness was Bob Town, and admitted Bob Town has not been served. And the magistrate seemed to agree with that. In page 2 of the magistrate's order, he indicates that the 30B6 style October subpoena called for both Coyote Stone and Bob Town to appear with a corporate designee to produce documents and testify. And the magistrate at the last page said the parties agree that service has not been completed. Since there was never a dispute that Coyote Stone was served, that can only be referring to Bob Town. Thus, the magistrate and the parties all agree Bob Town was the targeted witness and was never served, not served with the subpoena and not served with the complaint. The court has no personal jurisdiction over the witness that was intended by the subpoena. I can understand that that Zynex may argue, well, we also intended Coyote Stone to be a witness. There's some problems with that, Your Honors. Section 7 and Rule 45 both contemplate calling a person, which can be a juristic entity possibly, to appear at an evidentiary hearing. Rule 45, however, says that person must be identified with particularity. When you say in your subpoena that's directed to a person as well as a company, and then say that another person should testify, in this case, they directed it to Bobtown and Coyote Stone, but then said Michael Fabroda should testify, or
well,
other.
That seems to be a different argument that you had in your briefs about the ambiguity and such in the subpoena. But let me make sure I understand your argument about the lack of personal jurisdiction and its significance here over Bobtown. If he had not been named in the subpoena, if it had just been directed to Coyote Stone, you agree that Coyote Stone here, there is personal jurisdiction over Coyote Stone, right?
No, Your Honors, because we believe that the combination of Section 7 and Rule 40.5 does not result in nationwide personal jurisdiction.
Okay, so that would require us to endorse that argument, right?
Yes, Your Honors.
So I understand.
And to the extent the court wants me to address that, I can do that as well. Our argument on that is very straightforward. I am aware of the court's decision in the PA, which involved ERISA, and that is exactly the point, which is that when it's a subject matter conferring statute that provides for national service of process, such like ERISA or civil RICO, that there's not really a problem with nationwide personal jurisdiction. Here, this is not a subject. The FAA is not a subject matter conferring jurisdiction. It's here merely by diversity. And while in diversity cases we use subpoenas all the time for nationwide service of subpoenas, I certainly do it in patent litigation, that doesn't confer personal jurisdiction on those people. So we don't believe the combination of the FAA, which doesn't provide for personal jurisdiction, doesn't provide for subject matter jurisdiction. We don't believe somehow the combination of that with the 2013 amendments to Rule 45 creates nationwide personal jurisdiction.
So you don't want us to follow the 11th Circuit's approach?
No, Your Honor, I do not want you to follow.
So let me ask you, and certainly my colleagues may have more questions about this specific argument, but let me just ask you, if we were to reject your argument contra the 11th Circuit and instead follow the 11th Circuit's approach in managed care, what is left of your argument, your personal jurisdiction argument? So in other words, we don't follow the managed care approach. We recognize there was no personal jurisdiction over Bobtown, but there is personal jurisdiction over Coyote Stone. What happens next?
That ends the personal jurisdiction argument, Your Honor, with the exception that we don't believe a Rule 30b-6 style subpoena can be enforced for an evidentiary hearing.
Okay, so let me ask you a question about that. Why should we assume that this subpoena is some sort of a prohibited subpoena in the context of the FAA? It says it's for an arbitration hearing. It's directing the presentation of testimony by a witness and documents. It satisfies the presence requirement. The arbitrator is going to be there. So I guess I'm not understanding why we should construe this as some sort of a prohibited, pretrial discovery subpoena when it on its face contemplates otherwise.
Well, Your Honors, I respectfully disagree that on its face it contemplates otherwise, because on its face it looks exactly like a Rule 30b-6 notice. It calls at least both Bobtown and the company. Let's assume we excise Bobtown out. It just calls the company. It asks for the corporate designee to testify. Well, the only place in the Federal Rules of Civil Procedure that exists is Rule 30b-6, and I've used it, frankly, numerous times. But you can't use it for a trial subpoena. You can't use it for an evidentiary hearing. It's only for pretrial discovery. And Section 7 of the FAA does not allow for pre-trial discovery of non-parties.
Counsel, can I ask you about going back to personal jurisdiction, you and Coyote Stone in particular? As I understand it, they were properly served, Coyote Stone, the complaint through the summons, right? But
that is correct, Your Honor.
Okay, so why doesn't that confer personal jurisdiction over Coyote Stone?
Because there's no evidence they've ever been in the state of Colorado. There's no evidence that the state of Colorado has any personal jurisdiction over Coyote Stone. They've been tagged with the service. I mean, just because you've been served with a complaint and summons doesn't mean that you can't challenge the personal jurisdiction because there's not minimum contacts. But certainly, if you haven't been served, there is definitely no personal jurisdiction.
Okay, so the Rule 45 argument about nationwide service as it relates to Coyote Stone is not necessarily applicable. What you argue with Coyote Stone has to do with the minimum contacts.
Well, what we argue, Your Honor, is that you do have to have minimum contacts if there's no nationwide personal jurisdiction. That is correct, Your Honor. Your Honor, another issue that we have is, I've addressed the Rule 30b-6. The only case we were able to find on the issue, there's lots of cases that say you can't use Rule 30b-6 for purposes of a trial subpoena or an evidentiary hearing. The only case directly on point, and we cited in our brief, we cited it to the magistrate as well. He apparently didn't read it, was a Southern District of New York trial court case where this issue was actually looked at by the judge in the Southern District of New York. And he said, no, you can't do a 30b-6 style arbitration subpoena under Section 7.
So again, just going back to that, what is it about this subpoena that counsels, let's assume that a 30b-6 style subpoena is a prohibited thing in this context. Let's just assume that is so. I'm not totally sure that's right, but let's just assume it is for purposes of the argument. What on the face of this subpoena should direct us to conclude that it is a pre-trial subpoena? I pointed out some of the factors that don't favor your reading. And the most obvious one to me on its face is that it is calling for testimony and evidence at an arbitration hearing.
And perhaps I apologize for my lack of clarity, Your Honor. I definitely believe they are trying to use this as a trial subpoena for the hearing. And our argument is that this is clearly a 30b-6 style subpoena, which you cannot use under Rule 45 for a evidentiary hearing.
So your position is, despite what it says, it's actually something else, right?
Well, our position is that it is what it says. It's calling for a company's corporate designee to testify at an evidentiary hearing, and we're saying you can't do that under Rule 45. Now, another issue we brought up, Your Honors, and we found no case law on this at all, was Section 4. This is a case where there was a petition to compel arbitration, and that petition was granted, and that was granted by the District of Colorado. And under Section 4, the unambiguous language is that the hearing and proceedings shall be in the District of Colorado. The magistrate, and we pointed out that having a hearing in Vancouver violates Section 4. The magistrate...
Can an arbitrator sit in more than one place?
There's some open question on that, Your Honor. There seems to be a body of law that says the arbitrator is sitting wherever the arbitration is where the basis of the arbitration is being administered. That doesn't seem to rule out the idea that the arbitrator might have a hearing other than where he's normally sitting. But that lends to really crazy outcomes if you take into account issues in Rule 45.
So there's one argument that you raised. I want you to help me understand it. It seems that one of the many arguments that you are advancing in support of reversal here is that this hearing was set to occur in front of a magistrate, in front of the arbitrator in Vancouver. The arbitrator was sitting in Vancouver for purposes of this hearing. And so the court under Section 7 that had the authority to compel your attendance was not the District of Colorado, but was a district court in Washington. Am I understanding your argument correctly?
You are understanding our argument correctly.
Okay.
It is because
help me understand why that is so. And let me just add a couple of points. It seems that the facts here show there's one arbitrator, right? There's just one individual arbitrator here.
That is correct.
And the seat of arbitration is the District of Colorado. That's where the Section 4 petition was granted, right?
That is correct, Your Honor.
And so we would have to, in order to endorse your argument, we would have to agree that an arbitrator can sit in more than one place. Isn't that right?
Yes, I believe that is correct, Your Honor, but that raises a question. If the arbitrator is in Vancouver having a hearing, is he not sitting there when he's doing it? This is an unexplained area of the Federal Arbitration Act. The whole issue about having multiple arbitration hearings when Section 4 contemplates just one is really unclear. Is he sitting where he's holding a hearing?
Is one of your arguments that it was the Section 7 petition was filed in the wrong court? Is that one of your arguments?
Not exactly, Your Honor.
So help me understand it.
Our argument is that he could not do a hearing in Vancouver at all, because that would make him sitting in Vancouver, which would make the petition filed in Colorado to be incorrect.
Okay, so your position is an arbitrator can't sit in more than one place.
My position is, if the position of Coyote Stone, Your Honors, is that it's two-part. First, in a Section 4 controlled case, because it only applies when there's been a petition to compel the arbitration. In a Section 4 compelled case, the arbitrator can only sit and only hold hearings in that district. So when it's not a Section 4 controlled case, because it doesn't have to be, you can use FAA Section 7 when Section 4 is not invoked. In a non-Section 4 case, the arbitrator can sit in more than one location, and when it's in the other locations, it has to follow the rules there, which means that's where the enforcement has to be, and that's where a motion to quash has to be.
Counsel, can I ask you questions about your objections that you wanted to submit to the district court? And even if the district court was wrong, let's assume that they had no authority to review your objections. It would seem they have discretion whether or not to review the objections or to kick it to the arbitrator. Must the district court exercise that discretion, or why isn't it being able to submit objections to the arbitrator sufficient?
Because we're using federal statute to enforce that subpoena's attendance. If it's a private arbitration, well then yes, the only person who gets to hear those objections is the arbitrator. But since you are now using federal law, using Rule 45 to force someone to a hearing not of their choice in a fight that they're not a part of, then I believe in that case there must be an avenue of judicial review. I do want to add one thing, Your Honor, before my time runs out. Apparently is this my rebuttal time I'm going through? No. Okay, good. I do want to say this was not raised by Zynex, and we didn't specifically say it in our brief either, but we believe Coyote Stone is within the zone of interests to be protected by Section 4, or more specifically, the Federal Arbitration Act as a whole. We believe it should be interpreted as a whole. Section 2 creates enforceability of agreements. Section 4 says you can petition to enforce the agreements, and that's where the hearing has to be. Section 5 provides for appointment of the arbitrators for that hearing, and Section 7 provides for getting witnesses to that hearing. So we believe, if you read the Federal Arbitration Act as a whole, that Coyote Stone clearly falls in with the zone of interest to be protected by the Act.
Is that in service of what? Responding to what the district court described as perhaps a standing problem?
That is, you're right. I was puzzled. I was frankly puzzled, Your Honor, at the district court's decision on that, because I remember Lucas versus South Carolina Council, which came out when I was in law school. So I know the general standing doctrine fairly well. And it's like, this clearly applies to my client, because this is definitely an injury and it's caused by this. It's a hearing they don't want to go to. So I then cast about, I thought, oh, maybe he's suggesting, without using the language, that Coyote Stone is not within the zone of interests of Section 4. So I did want to address that if the court was going to ask any questions about it.
Thank you, counsel.
Thank you.
Ms. Plimpton?
Good morning, and may it please the court. So I just wanted to address first the issue of Section 4 and Section 7 and how the interplay between them. So I think that the court should absolutely affirm the district court's ruling in that Section 4 and Section 7 have completely different purposes. And if you look at Section 4, you can see it from the first sentence. It says a party aggrieved by the failure of another to arbitrate under a written agreement may petition for enforcement of that agreement. It's simply not at all related to the type of relief and the purpose of Section 7. If you keep going in Section 4.2, it discusses the court shall hear the parties. Those are the parties to the arbitration. And then it says that the court shall make an order directing the parties to proceed to arbitration in accordance with the terms of the agreement. There's nothing.
How about the next sentence? The next sentence says, the hearing and proceedings under such agreement shall be within the district in which the petition for an order directing such arbitration is filed. I'm struggling with how to read that sentence as not suggesting that here the proceeding needed to be in, or the hearing that the subpoena speaks to needed to be in the District of Colorado, which is where the arbitration was filed.
Yes, I understand your question. So the arbitration is taking place in Colorado. That it's in accordance with this Section 4. The proceedings and the seat of the arbitrator is indeed in Colorado. But there's no reason that the arbitrator cannot have a portion of the hearing somewhere else, especially where the parties to the arbitration did agree to that. And there's case law that supports this idea. No court has found that the arbitrator is not allowed and the parties are not allowed to choose to hold a hearing somewhere else for purposes of obtaining this testimony under Section 7.
Okay, so if I understand your position, it's that because the language of Section 4 incorporates the parties' agreement, and here Zynex's arbitration protocols suggest that the arbitrator gets to decide where the hearing is held, right? Am I right so far?
Yes, that's correct.
So this sentence incorporates your agreement, right? So if the arbitrator in this case decides with the agreement of the parties authorized by Section 4 to have a hearing in Vancouver, is he sitting in Vancouver for purposes of the hearing that you're having there?
The seat of the arbitration remains the same. It remains Colorado.
Why?
Right. So no, I would not say that for purposes of Section 7, the arbitrator is sitting in Washington. The arbitrator is simply exercising his authority, right, as the presider over the arbitration to conduct an evidentiary hearing for purposes of obtaining this testimony, which is exactly what Section 7 contemplates. It requires an in-person hearing. We set an in-person hearing. It requires the parties to appear before the arbitrator in a sort of an evidentiary rather than a discovery setting. So that's exactly what happened here. And
so then help me understand the language in Section 7 that speaks to which court is the one that can that has the authority to order a party to compel a party to comply with the subpoena. It says upon petition, the United States District Court for the district in which such arbitrators or a majority of them are sitting may compel. So your position is that notwithstanding the fact that there is a hearing in Vancouver in which the arbitrator is present, the arbitrator is still sitting in the District of Colorado. I mean, my question is, did you file this in the wrong court?
I understand your question. We did not file this in the wrong court. The Stolt-Nielsen case, I think, is very instructive on this point. We cited that in our brief. The arbitration is being conducted in Colorado. It is simply a hearing that is taking place in Washington, and that's under Section 7. There's nothing in Section 7 that prohibits the arbitrator from holding a hearing in another state, because the arbitration is still taking place here in Colorado.
What is happening in Colorado? If Mr. Forboda is in Vancouver and the evidence you want from Coyote Stone is in Vancouver, and Zynex is going to show up in Vancouver, then what's happening in Colorado?
Well, the arbitration is happening in Colorado. We have a
But what is-
Colorado-based.
But what does that mean exactly? If all the parties are in Vancouver and you're all getting together for this taking of evidence, and you're saying, well, it's happening in Colorado, but what is happening in Colorado?
Well, actually, the parties to the arbitration, the respondents there are not in Colorado. They are in other states. And the arbitration agreement says that Colorado is where the arbitration takes place, and in fact is where the arbitration is taking place. The arbitrators is here. They are elsewhere, but to the extent that we do eventually have our final merits hearing, it will be here in Colorado. I mean, most
So
likely.
the agreement to move the hearing to Vancouver was limited to one hearing in which the Coyote Stone evidence was to be presented, and that's it.
Absolutely, that is correct. And the only case law on this point supports that the propriety of doing that. And I don't think there's anything that suggests that you cannot do that. Section 4 is directed to something else entirely.
So Mr. Rylander said the clearest path to reversal is that Bobtown was never served. So there's no personal jurisdiction conferred. So what's your response to that?
My response to that is that there is unquestionably personal jurisdiction against Coyote Stone. Bobtown is not a party to the petition. So the council is referring to the underlying service of the subpoena, and the district court has discretion. It is an abuse of discretion standard whether to enforce the subpoena or not. The jurisdictional analysis does not relate to Bobtown. This case that was before the district court is between Coyote Stone and Zynex. So I think it's a non sequitur. Council concedes that service was proper against Coyote Stone.
So, and you allude to this in your response brief. So personal jurisdiction was conferred by the service of the petition through the summons, not through a Rule 45 subpoena service.
I'm sorry, can you repeat that? There was a little background noise.
Yes, and you alluded to this in your response brief, but I think I just want to confirm I heard what I think the argument is you're making, which is the jurisdiction, personal jurisdiction over Coyote Stone was properly conferred when Coyote Stone was served a copy of the petition via the summons once that was filed. It has nothing to do with the service of the subpoena under Rule 45. Is that the argument you're making?
That's correct, because Rule 45 confers, nationwide service of process is appropriate. It was incorporated into Section 7, and Coyote Stone was served. There's no dispute about that. Coyote Stone was served with this petition and also was served with the subpoena. There's no dispute about those 2 points. And if there's not another question on that, I wanted to just relatedly, the idea that this subpoena is a 30B6, it is not. These are not topics. It is not seeking a deposition. In a 30B6, as we all know, you're looking for someone to be prepared to testify about topics. The Exhibit A of the subpoena is about documents, and it says specifically it's a request for documents. It is not a request under 30B6.
Well, it requests a corporate designee.
It requests a corporate representative as a witness to come to the hearing and bring documents. Because we're obviously it is service. It is a Coyote Stone, which is an entity that we seek to get the testimony of. There's case law cited in our brief that is appropriate when you need a corporation to testify that you would be seeking a corporate representative, because a corporation obviously cannot speak other than through a representative. So that's what we did there.
Counsel, you mentioned the Stolt-Nielsen case as supportive of your position. In that case, was the arbitration proceeding in a state different from where this evidentiary hearing was with the third party was compelled?
So, yes, because the proposition in that case was that they held that the arbitrator can decide to hold a hearing somewhere other than the seat of the arbitration. So that was the same issue that we're dealing with here today.
And was when was the issuing court, the court that was compelling compliance, located in the seat of arbitration or at the site of the hearing with the third party?
The issuing court was at the seat of the arbitration, which was appropriate because that's what Section 7 requires. There's also this case Tyrone, which has been cited in the briefs, and which was the flip of that. The parties were seeking to have a hearing outside of the seat of the arbitration and filed the petition in the state that was not at the seat. And the court there said, you filed it in the wrong place. You should have filed it at the seat of the arbitration. So again, supportive of the idea that there's a seat of an arbitration, but there is also the ability to hold a hearing outside of the seat of the arbitration. There really cannot be a dispute that the arbitrator is sitting here in this Colorado arbitration, and that the purpose of this hearing is to obtain that testimony and that evidence, and the parties had agreed to that, and that was within the arbitration.
I think that's what I'm struggling a little bit with, is that, in order to satisfy the requirements of the FAA and Rule 45, you have to have the arbitrator present. You can't just do a pre-trial, 30B6. I mean, you can't do that under the FAA. So you're complying with the presence requirement. On the face of the subpoena, the arbitrator is going to be there. And what that seems to suggest is that he's sitting both in Vancouver for purposes of this hearing, but he's also sitting in Colorado, where the seat of arbitration is for purposes of the arbitration. And I'm just not sure that I've seen case law that speaks to that issue, that can an arbitrator sit in two places?
Absolutely. I mean, Stolt-Nielsen does speak to that issue, okay, as we've discussed. And also in Hay Group, this is a Third Circuit case. The court held that, that you can have a subpoena where the non-party is called to appear in the physical presence of the arbitrator. So because you're allowed to do that, it can be, anywhere else, really anywhere. It doesn't change.
That's what I'm struggling with. Is I think you have satisfied the presence requirement. I mean, it feels to me, based on what the statute requires, this subpoena complies with that. My concern is which court is the court that is authorized under Section 7 to compel attendance. And that, I think that question depends on where the arbitrator is sitting.
I agree with you. And I would ask the court to find that the arbitrator is sitting here in Colorado and follow the reasoning found in Stolt-Nielsen.
Maybe I try this another way. Would it be possible under the FAA for Zynex to have filed a Section 4 petition compelling arbitration in Colorado, but then filed a Section 7 petition to enforce the subpoena in the Western District of Washington, because that's where this hearing was going to be?
I don't believe that Zynex could have properly filed a Section 7 petition in the District of Washington because the arbitrator is not sitting in the District of Washington. And I would just, for the court's consideration, a party does not have to file a Section 4 motion to compel. So the parties can just agree to proceed with the arbitration. It so happens that we did have to file a motion to compel here. But, if we hadn't, Section 4, again, this just shows that it's really not at issue. We are simply proceeding under Section 7, which has to be read on its plain language, right? And so I don't think that reading a conflict into the FAA is the right, move for the court to make. I would suggest that it should not do that. You should read the statute as a whole. And so to read in a conflict, I think, would be problematic. I just also wanted to quickly it looks like I am out of time, but we would just rest on the remainder of the briefing and ask the court to affirm.
Thank you, counsel.
Thank you.
I think Mr. Rylander, you may be out of time.
That's correct.
Okay. Thank you both for your helpful arguments. The case will be submitted.
Thank you.
Colleagues, should we keep going, or do you like to take a break, or keep going? Keep going. Okay. All right. Okay, we will continue through. We'll call our next case, 24-1341, United States versus Jackson. All right, looks like we've got our lawyers. All right, Ms. Carter, you can proceed when you're ready, please.
Thank you. Just checking you guys can hear me okay?
We can hear you great.
Great, thank you. Good morning, and may it please the court. I'm Elena Carter from the Federal Public Defender's Office, and I represent Caleb Sean Jackson. The question presented here is whether officers properly executed a search warrant when they stopped and searched Mr. Jackson 1.5 miles from the authorized premises. The answer to that question is no. Attachment A describes a location to be searched. That's in the header. The first two sentences then describe the subject premises at 614 Robb Road, where it is, what it looks like, and the final sentence says the location consists of the subject residence, surrounding property, and all outbuildings and vehicles located thereon, and to include the person of Caleb Sean Jackson at the time of search warrant execution. It's all describing a location, which includes Mr. Jackson when the warrant is being executed there, not anywhere he happens to be, not anywhere in the district. Because Officer Newman clearly exceeded the warrant scope, you should reverse.
Ms. Carter, can I ask maybe a more threshold question, which is, I'm trying to understand what it is that officers did in terms of conducting a search of Mr. Jackson, because I don't read your brief to contest that they could make the traffic stop, which is in effect a seizure that occurred at that point. But you're arguing that they can't search him, though, because he has to be at the Robb Road location. But did they search him? Because as I see the video, once they stop, they just have a discussion with him, and he essentially just hands over his phone. So, help me understand what actions they took during that traffic stop that in any way could offend the Fourth Amendment.
So we are challenging that they couldn't have stopped him at that moment, that was not authorized pursuant to the warrant. Sorry, I'm hearing a little bit of echoing on my end.
Sounds okay. You can keep going.
Okay. And I think that stop is framed, and to quote from the government's answer brief, that stop is framed by Officer Newman's misleading statements about the scope of the search. So I guess I'm jumping ahead to inevitable discovery here, but I don't think he voluntarily would have handed over the phone if Officer Newman hadn't misrepresented the scope of the search by saying, I believe the very first thing he said was, we have a warrant to search your residence and you and all your electronics and your car. But we are challenging that the stop itself was not authorized via that warrant.
Wait a minute. So your argument is, as they observe Mr. Jackson drive past them, that because he's not on the Robb Road premises, that they could not lawfully even stop him at all at that point.
Correct.
And did you make that argument in your brief?
Why couldn't they I'm sorry. Finish your response.
I don't know that it explicitly came up in the briefing. I believe that, but we have said that the various warrant exceptions that the government has raised are too speculative, and I don't think probable cause is the end of the analysis as it relates to inevitable discovery. So I guess I'm getting at, we're not assuming without conceding that there was probable cause to stop Mr. Jackson at the moment that he's driving by, I don't think you still get to the phone under those scenarios because of how Officer Newman's statements colored the entire interactions.
If they have probable cause, not pursuant to the power given in the warrant, but pursuant to the information that was accepted by the magistrate signing the warrant, didn't they have sufficient cause to stop him? Because there was probable cause that he was committed crime and that he had evidence of the crime on him.
Sorry, Your Honor. So to answer your question, assuming without conceding that there was probable cause to stop him at that moment, and I don't think there was, but even if there was, the government hasn't raised under inevitable discovery probable cause plus search incident to arrest, and that's for good reason because
they did reference as a part of their argument on inevitable discovery a Terry stop, didn't they?
Yes, but again, you could have reasonable suspicion to pull him over, but it's far too speculative to say he would have consented to the search and voluntarily handed his phone over when, again, the first thing that Officer Newman said to Mr. Jackson was, we've got a search warrant to search your place today, as well as you and all your car for all of your electronics. So I don't think he would have handed over the phone in that scenario. That's far too speculative to get to inevitable.
Anna, when we think about inevitable discovery, aren't we very careful to not think about sort of speculative conduct by third parties? We're looking at the acts of the government, right?
Yes, you're correct, Your Honor. We want to look at what, if the government has met this burden by preponderance, that the evidence in question would have been discovered in the absence of the Fourth Amendment violation. And here, if you take away that Fourth Amendment violation, the improper execution, well, if the warrant had been properly executed at Mr. Jackson's residence at that time, he wouldn't have been there. And I don't think that the automobile exception, the Terry stop for reasons I've just gone into, would inevitably get them the phone. It's far too speculative to say that the stop would have occurred just as it did with when you have that clear statement by Officer Newman, we've got a search warrant to search you, your phone,
Counsel,
your car.
Let me redirect you back to the beginning of your argument because we've started talking now about exceptions. As I understand, your principal argument is the warrant is valid but improperly executed, right?
Correct, yes.
And the last sentence of attachment A says, and to include the person of Mr. Jackson at the time of the search warrant execution. And your position is that we should read that as limited to the premises, right?
Correct.
Is there a equally fair reading that it is not limited to the premises, rather it is limited to the time that the warrant is being executed?
No, there's not. And I would address, first of all, the government's argument that about the placement of two serial commas, one that ends the list, all outbuildings and vehicles, and then one comma, and to include the person of Caleb Sean Jackson. But the commas merely organize elements within a single definition of location to be searched. And as we argued
I'm struggling a little bit with why we're talking so much about commas, both our position and I'll also ask Mr. Gwell about it, the government's position, because our case law says that we have to look at this in a very practical way, that we're not doing statutory construction on warrant language, right? And
yes.
So my question is, leaving aside for a minute sort of a more technical grammar-focused approach, why isn't it an equally reasonable reading of the warrant that the person of Mr. Jackson is included here at the time of the search warrant's execution, that it's not premises driven, it's temporally driven?
I think that's because the header says description of location to be searched, then the three sentences in that paragraph below that description are working together to define the location with increasing specificity. And then the final sentence, location consists of, and to include Mr. Jackson, that clearly pulls him into the location. And to pull him out of location just based on the place of 2 commas, I agree you don't have to get into the commas. I think it's a stretch to say the mere placement of 2 commas pulls him out of that location when attachment A is wholly aimed at defining what property and people are components of that location. So it's a strained and hyper-technical reading to pull him out of that location.
If we, I guess I want to ask you a question about the role of ambiguity, how we should be thinking about the role of ambiguity in this case. If the warrant here is attachment A is susceptible to equally reasonable readings, and we conclude that the practical reading of the scope here could be clear, it's ambiguous, how should we be thinking about that? And specifically, does that inform how we should be thinking about the good faith exception?
So the 10th Circuit has repeatedly said that good faith doesn't apply to save an improperly executed warrant, full stop. And I think Leon itself doesn't leave an opening to expand the doctrine such that ambiguity triggers good faith to save improper execution of a valid warrant, because it's very clear in Leon that good faith, of course, assumes proper execution, i.e. that's a prerequisite here. So I think full stop the ambiguity, if you ultimately decide that our reading is correct, that execution here was improper, you don't do that second step of analysis of good faith as a means to save the improperly executed valid warrant here. And I would also point you to the Young case, which would be an example of a genuinely ambiguous language as to scope, but where the court nevertheless did not see an opening to expand the doctrine in the way the government is asking you to do. And the holding and the court held in that case.
Is Young the unpublished case?
Yes, it's unpublished, but I do think it's persuasive as a case where there was genuinely ambiguous language, unlike in our case where we think there was no ambiguity here. But Young is persuasive in that the court ultimately said because the validity of the warrant is not challenged, and we've concluded that the warrant did not authorize a search of the defendant's person apart, untethered from location, we also conclude good faith did not apply. So I think that's a clear statement that the validity of the warrant is challenging the validity of the warrant is one of those prerequisites to applying good faith. So I don't think there's an opening here to expand the doctrine in this way.
But if we find ambiguity in the warrant, do you lose on good faith?
No, if you find ambiguity in the warrant, but ultimately find that we're right, we don't lose. You don't go to that second step of analysis. I think regardless of how you decide whether in our favor or for the government as to execution, you don't need to go to that second level of analysis here.
So regarding ambiguity, I mean, the target of this investigation or the purpose is to try to uncover evidence of child pornography offenses. And they're looking for electronic devices. The only reasons to search his person are, one is for safety, but also for his cell phone, because evidence of child pornography on his person would almost exclusively be the cell phone. So when we think about what the warrant is authorizing in terms of searching his person, why wouldn't a practical reading be, well, you can try to find his phone on his person. You have to do it at the time you're doing the search altogether, but it doesn't matter if he's on the Rob Road property or not.
Well, I think Officer Newman's intent or strategic reasons for writing the warrant one way or another are irrelevant, because I think the plain reading of this warrant is that you can only search him in connection with those premises. And I think the affidavit clarifies our position in that it's very location focused, and it only describes Mr. Jackson in connection with executing the actual search warrant. It only describes him instrumentally as using his biometrics to open devices that are found at the quote subject premises. So I think we look at the four corners of the warrant here, and I can't speak to Officer Newman's intent or strategy between writing the warrant one way or the other, but I do think the language is unambiguous that you can only search Mr. Jackson when he's at or in the immediate vicinity of the subject premises. And I would like to reserve the final time for rebuttal unless there's a question.
Wait a minute. Before you reserve, would it be inappropriate for us to look at the government's inevitable discovery argument, realizing the facts are basically undisputed here, and look at it and say that the warrant gives them a basis to make a Terry stop, and that they can do the search pursuant to the Terry stop, which is the phone. And that the only problem here is that the government characterized this approach, because their approach was premised on Terry, as inevitable discovery, is that they just put the wrong label on it. Is there anything wrong with us pursuing it in that fashion, saying it was a Terry stop, a proper search pursuant to that Terry stop? And what's the problem?
I disagree.
Why couldn't we do that?
I disagree that the Terry stop would have inevitably led to getting the phone, first of all. But also I would add that the 10th Circuit has never applied inevitable discovery to save an improperly executed warrant. And
no, we're not. You're missing my point. Are we permitted? I'm saying, I think the government mislabeled the theory. It's not an inevitable discovery because there was no Fourth Amendment violation, because the stop, I think, looks like it's okay under Terry, so there's no 14th Amendment, there's no inevitable discovery, because that requires a 14th Amendment violation to precede it. So why can't we just go on from there and say it was a proper Terry stop, and the phone was there and they could search it? What's wrong with that?
Well, I don't think the Terry stop would have inevitably led to getting the phone, because that would assume that Mr. Jackson would have still handed the phone over to Officer Newman. Again, we're getting...
Well, no, it's a Terry stop. They have to make sure that he can't get away with anything that can be destroyed and everything. And he got this phone. You can't just, let him have the phone. If you have a proper Terry stop, you have to take the evidence that he has. Basically what I'm asking is there anything unfair with us recharacterizing the argument that the government makes from inevitable discovery to a Terry stop and its natural consequences of a roadside search? Is there anything wrong with that? Is it unfair to do that?
I'm not sure how to answer that, Your Honor, candidly, as that wasn't something that came up in the briefing, so I don't want to give the wrong answer.
I think that answers it. I mean, the government called this an inevitable discovery exception. So that's what they're here to argue.
Well, you would agree that the facts are undisputed, wouldn't you, Ms. Carter?
Yes, I believe it's just legal arguments here. The only factual argument that was disputed below was whether the phone was on his person and under his control at that point in time of the stop, but I don't think either side is challenging that on appeal.
Okay.
Thank you. We'll hear from the government.
May it please the court, Bishop Grewell on behalf of the United States. Given the conversation that's occurred so far, I think I'll probably start briefly with what we've called inevitable discovery, and then I'll address Judge Rossman's questions about what to do with the ambiguity here. I think there are two different ways that the ambiguity could be approached if this court considers there to be an ambiguity in the warrant. As far as the inevitable discovery, I suppose it could have also been labeled independent source. I don't think there's any speculation required with regard to this. The officers could stop him because not only did they have reasonable suspicion, they had probable cause that he had committed a crime and was committing the ongoing crime. of possessing illegal child pornography based on everything that's in the affidavit. They knew the vehicle he was driving was him and had a personalized plate you can see in the video that was referenced in the affidavit. We had all of this stuff in the affidavit about how people who have contraband keep it on their phones and on digital devices that are on their person. And so once they could stop him, then whether it's a search or not, the automobile exception would have, even if he hadn't handed over the phone, the automobile.
The only reason that they could stop him is as they were invalidly executing the warrant, right?
I don't think that's correct, Your Honor. I think they could have stopped him to arrest him. They had PC that he was committing an ongoing offense at that point. So I think they could have stopped him even without the warrant, based on that information they had that's in the affidavit. And then the only thing that...
But what if the warrant had been invalid? Here the warrant's valid and the argument is it was improperly executed. So does your argument depend on there being a valid warrant?
Well, if the warrant was invalid because of a lack of probable cause, that could be a problem, because we're basing sort of the PC here on the fact, the PC for the stop and the PC to search the car based on the stuff that's in the affidavit. But I don't think an invalid warrant based on the going outside the scope would create a problem with those things, because I think they're independent ways. Again, we could have stopped him and searched the vehicle. And then the officer testified on the stand, if this warrant that I had didn't cover the phone, I would have gotten a warrant to search the phone. And so I don't think there's any of the speculation required to answer that particular exception.
So really the reliance is not on the warrant, but on the basis that the warrant was acquired, i.e. the application. And the application has sworn testimony that we know what this guy has done. We know how he has done it. And we have him on the roadside, and we have access to the phone, which is one of the instruments of the crime that's mentioned in the application, correct? Is that
correct? And they haven't challenged that. And possession of child pornography is an ongoing offense. It's a continuing offense. So every moment, it's a crime that is ongoing. Okay, here is the problem I'm having with that. I think that makes perfect sense. But it's asymmetrical the way the approach is, because you say it's inevitable discovery. And I just don't see that, because if the Terry stop was appropriate, there was no preceding 14th Amendment violation, which is the standard traditional part of an inevitable discovery theory. Isn't that correct? Which I think these often get sort of mixed up. I think that's why it could be an independent source better than inevitable discovery. That might be the better label for it. Because but you didn't even say that. All you said was inevitable discovery. You didn't say independent source. You didn't say forget the warrant. We could just stop this guy and take his phone. We didn't put that label on it, but we did put all of the necessary facts and all the necessary exceptions that we said this is why you could stop him, because there's probable cause, which would give you reasonable suspicion. We pointed out that you could then search based on the automobile exception. We then pointed out that he testified that he would have gotten a warrant. So it is correct. We didn't put that label on it, but all of the facts underlying that theory are there in the briefing. But here is something, and this is more in line with your inevitable discovery label. Eventually, the warrant was executed at the site, wasn't it? It was. Okay. And is it in the record what it was that you found at the site as distinguished from what you found on his person when you did the roadside stop? Is that clear from the record? As I recall, there were not devices that they found at the site. It was on his phone that the evidence which is why this matters in this case, because that is where the evidence was found through the search of his phone. Beyond what because if there were other things on the drive in addition to phone, that would fit inevitable discovery a lot better, wouldn't it? It would. I think the one inevitable discovery point that's still here, though, is we did need the testimony that look, once I had that phone, if it was not going to be covered by this particular warrant, I would have went and got another warrant. And so that is an inevitable discovery fact. We have all these other facts that are leading up to that chain, but that particular thing is something that, didn't happen as an independent source.
But that just sounds just wrong to say that I improperly executed a warrant, and in improperly executing it, I found this information. And so that would have led me to get a second warrant. That sounds awful to me.
I think where the basis is, we have all of this independent source that would have got us there to get this other warrant, which would be legitimate, and nothing is illegitimate in that chain. It makes sense when we're talking about the concerns about deterrence and the exclusionary rule.
But doesn't the second warrant depend on the propriety of your doing the search and everything at the roadside?
That is correct. Yeah, but again, I don't think it's a PC problem. I think it's a scope of that particular warrant problem. So I don't think it doesn't create a propriety problem in how the stop occurred or the search that occurred. I'd like to, if I may, turn to the questions about the ambiguity in the warrant, unless the court has further questions on inevitable discovery.
I did have one quick question on inevitable discovery. I just want to make sure that I understand exactly what the government argued. So your two arguments or your two theories in support of inevitable discovery was, one, you stopped him to provide him a copy of the warrant. That seems strange. Do you stand by that argument?
Yeah, I'm not pressing that argument.
Okay, you're not pressing that argument.
Yep. Makes
sense. The second is this Terry idea. And I think I want to just make sure I understand what you presented, because I think the in your questioning with Judge Murphy, the facts are undisputed. The facts are what they are. And if we break the causal chain and this is just an ordinary traffic stop, is there a reasonable suspicion for this ordinary traffic stop? That's a different kind of an inquiry. You did not make that argument, right? Your Terry stop argument, or actually, let me stop talking and have you talk. Tell me what the government's argument is under Terry as part of your inevitable discovery theory.
Yeah, I think our alternative argument I think it might be the Monteith case decision we cite. I can't remember which one it is, but that basically the fact that there was PC, that he is committing an ongoing crime, gives you at the very least reasonable suspicion. But you had PC, which is a higher standard. You could arrest him for that. You could stop him for that. The fact that he was committing an ongoing crime of possessing child pornography. That's the basis for the stop. And then once you've stopped him because you have PC that it's evidence of that crime or contraband is on his device under the automobile exception, you could get that device.
Okay, thank you.
Turning to the ambiguity question, I think there are two ways, assuming that the warrant here is ambiguous, I think there are two ways that the court could address this. Either, and these are both in some sense based on the footnote 19 language from Leon, where I think it suggests that as long as the officers are searching a place that they, quote, have reason to believe, end quote, is covered by the warrant, that's not the sort of thing that we're worried about here. So the first way that the court could address that is it could say, if officers are acting with reason to believe that something is within the scope of the warrant, we don't have a scope violation. We're not going to go to good faith. We're just going to say scope violations require officers to be acting unreasonably. Sorry, there was an echo. Unreasonably or requires the officers to be acting unreasonably. And there's simply no scope violation in that situation.
Okay, wait, hold on a second. So in that version of that argument, we would have to agree that the facts here support that this warrant was being executed reasonably when Mr. Jackson was stopped. Is that right?
That the officers had reason to believe that searching him off premises was within the scope of the warrant.
Okay.
And that's the language from Leon footnote 19, that they had reason to believe. The second way that the court could address it is by saying that good faith applies here, and that, in fact, while there's much dicta in the 10th Circuit, there's no holding that good faith doesn't apply to scope and execution, which I think is what the First Circuit says in its Pimentel decision in footnote 4. It discusses this court's precedents and says that the question of an ambiguity regarding scope has not come up in Angelos or those decisions. And so the 10th Circuit hasn't actually reached that question. And then based off of footnote 19 in Leon, that where officers have reason to believe, which they would in an ambiguity, that this is within the scope of the warrant, good faith would apply.
Well, let me ask you this. I mean, your friend on the other side here says that it's a full stop situation in terms of what our law shows. Leon good faith will not save an improperly executed warrant, period. You agree that that is a correct, at least descriptively, of the state of our law, right?
I agree that the court has said things like that, but never held that. That there's been no decision where an ambiguity has been in all of those cases. An ambiguity was never at issue. So I don't agree.
So we have held that, but your position is that because those cases were not adjudicating the sort of ambiguity argument you're pressing here, that is open in this circuit. Is that your position?
I think for it to be a holding, the issue has to be present in the case, and it has to be something that's required to make the decision. And I think that's why the First Circuit in its footnote 4 says this court hasn't decided it. But
even though you say what we've said, that Leon cannot save a faulty execution, even if you say that's dicta, doesn't that concept naturally flow from what Leon is all about? And that is that you have a faulty warrant on its face for some reason, but in good faith looking at it, you couldn't really tell that, versus some problem when you take this warrant and you execute it in an improper fashion. That seems to me on a completely different track than the whole theory of Leon.
I don't think it calls for a per se rule. I think that makes sense if you have an unambiguous warrant that what they did was unambiguously outside the scope, which is the cases this court has decided. I think when you have Leon footnote 19 saying, but if officers are acting based on a reason to believe that something's within the scope of a warrant, when something's ambiguous, I think they have reason to believe that it's within the scope of that warrant. And you're not getting to sort of any of the deterrence value that Leon is about. You don't have officers who are, intentionally trying to play a game here. In fact, it's quite clear the officers, based on everything that's in the affidavit, could have gotten the clear language. There's no concern that somehow the magistrate wouldn't have approved it if they had added on to say, and Caleb Jackson, no matter wherever he may be or whatever time, that wouldn't have been approved. And so I don't think the deterrence concerns that Leon has are there. And I think Leon says, again, in footnote 19, it's where officers have reason to believe something's within the scope of the warrant. We're not concerned about that. It's also, if this court's going to go the other way, I think it should acknowledge it is certainly creating a circuit split with the First Circuit in Pimentel. Pimentel said exactly the opposite. The Young case that they cite, it's unpublished, and it doesn't, with due respect, doesn't say what it's been presented to say. There wasn't an ambiguity in Young. Rather, in Young, this court said the clear command of the warrant was that they could only search the apartment, not the person. So the ambiguity wasn't at issue in Young, even if it had been published.
Help me, and if you can do it in 10 words or less, I'd appreciate it. But you may need more than 10 words. What is ambiguous in attachment A? And say that you can include the search of the person at the time of the search warrant execution, and that's at the place. How is that ambiguous? I don't get it.
I think when you have the language before saying located thereon, that indicates there's a geographic limiter. We don't have it at the end. If the person had been before that, a natural reading might include that. But he's certainly not a subcategory of those things that are listed, the buildings and the like. And the timing limitation is simply saying it's not an order of operations. It's simply saying this all needs to be part of the same temporal episode. So like you can't wait 3 days between searching the premises and him, but it's not saying you can only search him if he's on the premises at the time. That's
what is more instructive for a practical reading, which is what our case law demands. The sort of, commas and clauses and technical language, or literally the heading, description of location to be searched.
Yeah, so I think location is ambiguous here. That's the problem, because it doesn't just use a place. It has places, things, and people. And so it's not using location in the sense of a place when you have things and people included. That's why for the things here, the cars and the outbuildings, it needed to say that they're located thereon. And so I think that's not the pragmatic reading when you have that other context.
Do you know if in Pimentel, do you know if the First Circuit's law, you're suggesting that we would be creating a split here, is sort of the first premise in the First Circuit about Leon doesn't apply to improper execution? They hold that too, right? I mean, there's no circuit split on the black letter descriptive principle, right?
No, they say that it is not a per se rule, that in fact, good faith can apply to a search warrant that goes outside the scope and execution. They say that, I think quite clearly, it's several pages. It's pages 90 through 92. And there, the going outside the scope execution was actually much more egregious than here, because that one, the warrant said, you can search on the second floor of this 3-story building because that's where the residence of this guy is. Turns out they get there and they realize his residence is on the 3rd floor, and they go search the 3rd floor, which is clearly outside the warrant of that, but they decided that was ambiguous enough. This is far more ambiguous than that language, which was upheld under the good faith doctrine in Pimentel.
May I ask one more question? Counsel, the ambiguity in the warrant language, I think I hear you saying it's not ambiguous that you can search Mr. Jackson at the same time that you're executing the search at Robb Road, but it may be some ambiguity as to whether or not Mr. Jackson has to be on the property itself when you execute that search of him, if I hear him that correctly. But if that's true, you didn't execute the warrant or search Mr. Jackson at the time you were at Robb Road because the officers weren't at Robb Road yet. And you say in your brief, well, we were already executing the warrant when we stopped him. But what authority do you have for that?
So it's two things. We have the officer's testimony that really this stopping from the site was the beginning of the execution. We have the warrant that says the execution included providing a copy of the warrant when they stop him. And the third thing then is, as I was trying to say earlier, this isn't an order of operations. It doesn't say you have to start searching the outbuildings and the vehicles first. He's an independent thing. It all just has to be part of this same episode. And it clearly was. It wasn't too attenuated. They stop him, do that search, and then they immediately go to the property. So it's not like they waited 3 days. It was all part of the same episode. It basically creates a temporal nexus that was met here.
I mean,
Did they take Mr. Jackson with them from the roadside stop to the premises? Was he with them?
He asked to go with them.
Okay.
You use the word staging. Is that the same thing as executing?
I think that's a factual question actually here. I haven't seen a law, but that was the testimony of the officer that this was, we have the site in the brief where he said, this is sort of where we're starting the executing is them setting it up. And so I think that's arguably a factual finding in the record.
Thank you, counsel. Well, we kept the government an extra 4 minutes. Ms. Carter, put some time back on your clock, give you 4 minutes.
Thank you. I appreciate that, Your Honor. There's a number of things I'd like to have a chance to address. First of all, with Pimentel, I think it's inapplicable here because in the 10th Circuit, these types of address errors wouldn't serve to invalidate a warrant. And I would point you to Harmon versus Pollock for that proposition that a technically wrong address does not invalidate a warrant if it otherwise describes the premises with sufficient particularity. So that's one thing I would note there as to that First Circuit case. Since the footnote in Leon came up, I'd like to address that for a moment. Footnote 19 is simply describing the standard for evaluating whether an execution is proper. I don't think it creates an opening to expand the doctrine. And I also want to address the government's argument about the temporal work or the temporal restriction here. And I would like to point out that their argument as to how to interpret at the time of search warrant execution is completely circular and meaningless, whereas our reading, the meaningful work that phrase is doing, clarifies that Mr. Jackson can only be searched inside the act of execution period, but their reading at the time of search warrant execution is completely elastic in that officers can simply hand someone a copy of the warrant anywhere at any time and claim they're executing it. We can search Mr. Jackson because warrant execution has begun. Warrant execution begins because we hand him the warrant, or handing him the warrant because we're searching him. I think that just can't be. As to another point, the
but
idea
counsel,
of
that's not really
vehicles.
what happened here, though, isn't it? I mean, they're saying, they testified that the warrant execution begins once we stop him because we can serve the warrant upon him, and for other reasons we can stop him. But then they immediately go to Robb Road, in which he, I think, drives himself there to join them, right? So this idea, so I heard the government saying, well, there's a temporal proximity to the manner in which it was executed. We don't have to sort of think about the hypotheticals as to whether they could have stopped him and then the next day gone back to Robb Road.
Well, I wouldn't agree that the execution would begin that far out. I think the execution, you still have to execute the warrant properly at the designated location. And I would also like to, in my remaining time, address the point about the located thereon language. And the warrant already includes site-specific limiting language that ties Mr. Jackson to the location. So that's clearly the header. This location consists of and to include Mr. Jackson, which is clearly additive language. So you don't need to repeat located thereon next to his name. So the absence of that, I think, doesn't go either way. And even if you took located thereon away from modifying vehicles, I think it's still clear we're talking about vehicles on the property. So I do want to address that point. And I also finally want to say this isn't a matter of a quick fix like in Street, a case that you all are probably aware of, where you could just quickly tweak some of the writing in the warrant, because in Street we had a warrant that was invalid from its inception, but it was essentially signing off, though, on the same exact search. Here, it's not much of a quick fix because we're asking for a totally different, broader search here that the magistrate would have to consider. So with that, I will rest on our briefing and ask you to reverse. Thank you.
Thank you, counsel. Thank you both for your great briefs and helpful arguments. Case will be submitted. All right, we'll call our last case for argument this morning, 24-3159, McCray versus Collins. Okay, looks like we have our counsel ready. Ms. Randalls, got your name correct? Pronounced
Yes,
it
Your
correct?
Honor.
All right, you may proceed when you're ready, please.
Thank you, Your Honor. May it please the court. My name is Rebecca Randalls, and I represent Deshaun McCray in this matter. This is an employment discrimination case arising at the VA. Ms. McCray brought 4 causes of action: discrimination, harassment, retaliation, and constructive discharge. The court granted summary judgment on all 4 claims, and for that action, the court erred. There was a companion case, the Dial versus VA case, that was successfully litigated and involved the very same facts and the very same circumstances, save one. And that was that Ms. Dial actually quit the VA because of the discrimination, while Ms. McCray took an unfavorable transfer to get out from under her Caucasian supervisor, Ruth Duda. Importantly, Ms. Dial and Ms. Duda were so overworked by the end of their tenures at the VA, they were replaced by 4 people. The court, in its 64-page decision, limited plaintiffs' complaints, then, one at a time, knocked them out. the court became essentially an advocate for defense counsel. And honestly, defense counsel is quite good. They didn't need the court's advocacy in this matter. The plaintiff did establish that she had been treated less favorably than Caucasian employees in her supervisory chain.
Are you talking about the summary judgment?
Yes.
Issue? Okay. What specific evidence did she present that there was a different treatment of the Black nurses than the white nurses?
She presented a lot of evidence. She presented it on three specific levels. First, she presented evidence of her own treatment. Secondly, she presented evidence of treatment of others in her same supervisory chain. And third, she showed evidence of individuals who worked below her who were also Black and whom
did she present any evidence that there were white nurses that were treated better?
Yes, she did. She showed that.
Tell me what evidence is, and tell me exactly the page in the record that I will find that.
Well, I would have to pull out the record. I'm not sure I can.
All right. Well, tell me. Is it in her deposition? McCray's deposition?
It is in her deposition.
I thought she said in her deposition that Ms. Duda treated the Caucasian nurses. She disciplined Caucasian nurses too. Didn't she say that?
No. What she said was that since she was a supervisor, McCray was the supervisor, Duda would countermand any of the discipline that she would tell McCray to mete out to the Caucasian nurses, but she allowed that discipline for the exact same thing, no matter what it was, to go forward with the Black nurses. So she was currying favor with the white nurses by saying, oh, McCray is being far too difficult on you.
And you say that's in her deposition?
It is in her deposition.
All right. And you can't tell me what page is in the appendix or in the deposition where I will find that?
I'm not sitting here at this moment, but I can.
Did you put that in your brief, the record citations, where I can find that?
We did put it in the brief for the record citations. We also put it in the summary judgment.
All right. So you cited to her deposition, and I can go to those pages that you cite in your brief and see that she treated Caucasian nurses better than she treated Ms. McCray.
Yes, you will find that specifically in three ways. You will find it with regard to discipline and the disciplinary actions that were meted out to the the nurses that McCray was the supervisor over. You will also find it in the workload disparity between the Blacks and the Caucasians. Ms. McCray and Ms. Dial testified with regard to the work disparity between them. But with regard to supervisors, there were only two supervisors and both of them were Black. And so there is no information concerning similarly situated employees because the only supervisors at that point in time were people of color. And so,
but doesn't your claim require that you show that there is different treatment afforded to people?
No,
women.
I'm sorry.
My question. Who are similarly situated, and you told me there was nobody similarly situated to the two Black supervisory nurses.
Well, right? Just because you're a single individual working in an employment setting doesn't mean that they can then discriminate against you at will. The case law.
Discrimination, by definition, means that you treat one person differently than you treat another one who is similarly situated. So what I'm looking for is a similarly situated non-Black person who was not treated in the same way as Ms. McCray was.
Well, with regard to supervisors, there were only two supervisors and both of them were Black. And so there will not be a similarly situated supervisor in this area. However, when you look at the manner in which all of the Black nurses were treated, what you find is that all of the Black nurses were treated very differently than the white nurses. And under the 10th Circuit law, you don't have to have similarly situated individuals where the disparity is fairly clear.
Ms. Randall,
Okay,
can I go back? I'm sorry, Judge Murphy.
Okay, you mentioned a bunch of emails. Are those emails in the record?
Yes. The emails between Ruth Cummings and the plaintiff.
No. I thought you referenced some other emails that indicated actual discriminatory conduct. Are those in the record?
The emails that are referenced in the brief concern the emails between the plaintiffs and Dr. Cummings, who was the
Cummings. Okay, all right. Those are the only emails you're talking about. Okay, I'm fine. I'm sorry, Judge Federico.
Oh, you're good. Ms. Randalls, I wanted to ask to go back to your first sentence. You said that Ms. McCray raised 4 claims that were all dismissed at summary judgment. However, my reading of the record is that counts or claims 2 and 4 were actually dismissed at the pleading stage. One of them for failure to allege an element and the other for failure to exhaust. In your opening brief, did you adequately argue against the district court's reasoning for those dismissals such that we can consider that preserved before us on appeal?
With regard to the dismissal for failure to exhaust, yes, that is adequately briefed in this briefing before the Court of Appeals. With regard to constructive discharge, she wasn't technically discharged, and so probably the court got that piece right, that she wasn't discharged. Instead, she had a transfer to Colorado that was disadvantageous, which is the damage that results from the retaliation and the harassment and the discrimination that she experienced. And so I believe that all of the claims were completely exhausted, but with regard to constructive discharge, because she wasn't technically discharged and she didn't quit the agency, we have not proceeded further with that particular claim.
So in other words,
under constructive discharge.
Under constructive discharge.
You say there's no appeal of constructive discharge.
Correct. We haven't provided any information concerning that claim.
All right.
Our biggest concern with regard to this case is the manner in which the court has limited the claims and then knocked them out. The court did this by first acting as the trier of fact, accepting the defendant's statements of fact as true. Second, he limited plaintiff's claims to only discrete acts, even though the complaint, the informal complaint, the formal complaint, and the petition in front of this court all established that the acts were ongoing in nature.
Counsel,
yes.
If I understand your argument correctly, or where you might be going is as to the district court's treatment of the continuing violation doctrine here. Is that right?
That's part of it, but the court also.
Well, let me ask you about that.
Sure.
You agree that does not apply when we're talking about your discrimination and retaliation claims, right?
I would agree that the 10th Circuit case law at this point in time says that continuing violation is not a theory that can be followed in the 10th Circuit.
Okay, so help me understand your argument about how the district court, you claim, erred in its treatment of the discrete acts here as part of its analysis of your discrimination and retaliation claims.
Well, what the court did was it limited every claim to 8 acts that were set forth in the acknowledgement letter sent by the agency EEO officer. That's not proper. It's not proper on 2 bases. First, because anything that's like or related to those claims should also be part of the case pursuant to the law of the state. The second reason it's not correct is because she did allege ongoing harassment and ongoing retaliatory harassment in both of her informal complaint, her formal complaint, and in the complaint before the court. So knocking out all of the information in there that says these acts continued from 2018 until the present indicates that there's a continuing issue that's going on. Each of the, then if he wants to just deal with discrete acts, you have to look at all of the discrete acts that were administratively exhausted, not just the discrete acts that were specifically listed in the acknowledgement letter from the EEOC before the formal complaint is even investigated. Everything that comes out has to come out of the investigation, not just out of what is accepted.
Doesn't our law say otherwise? I mean, isn't our law pretty clear that you're limited to the charge itself, the EEOC charge itself?
No, the law of the state, the law of the circuit is that, and it's Smith versus Cheyenne retirement investors, the law is that a claim is limited by the scope of the administrative investigation that can and the language is this, that can reasonably be expected to follow the charge of discrimination. In this case, the charge of discrimination said that between 2018 and the present, I have been discriminated against in the following ways. I have had my authority usurped. I have had my workload increased. I have had, and then she went through a series of those. Then there were specific examples given in the formal complaint. There were 8 specific examples identifying how each of those things had occurred, but that's not the whole of it. It's each of the times that she was usurped, each of the time that her authority was undermined, each of the times that there was a workload disparity or that her workload was increased. All of those things are part of this complaint. You cannot limit it to merely the 8 things that were on the table that the agency picked out of her informal interview and out of her formal complaint. It has to be limited only by the scope of the administrative investigation. Now, the court overly relied or they over extrapolated from the Smith case. In this case, all of the claims that plaintiff talks about in her summary judgment motion, in the petition, and in her appellate brief were fully investigated. Not just that they were talked about during the course of this case, but they were investigated. And once they're investigated, then administrative exhaustion occurs. The court held that administrative exhaustion can't occur under Smith because it's limited solely to what's in the complaint. That isn't accurate. What the Smith case said was that the information that is produced by the defendant cannot be used to expand the plaintiff's complaint. We don't have that situation here. In the administrative complaint itself, the plaintiff established, Ms. McCray said, these acts have been continuing from 2018 to the present in one of the situations. In the other one, she said from 2019 to the present. And so those are by nature acts that occurred over and over and over again. And to the extent any of those acts were investigated, those acts are part of this charge and part of this case, and they were administratively exhausted. The next thing that the court did, not only did it accept as true everything that the defendant alleged, even where plaintiff had specifically controverted those, the court accepted as true the defendant's allegations. That's improper. The court is to act solely, not as a super jury, but is to act solely to determine whether or not there's sufficient information in the complaint to allow the case to go forward to a jury. That didn't happen in this case. Instead, the court acted as a super jury, taking as true what the defendant had produced. And there were situations such as what was said to Dr. Cummings, where there's only 3 people in the room. 2 of them testified that they told Dr. Cummings about discrimination, and the court accepted that he was never told that discrimination had occurred when we have both the testimony and we have the emails.
You're out of time.
Thank you.
Thank you, counsel. Mr. Vandersby.
Thank you. Can you hear me okay?
We sure can.
Yes.
May it please the court, Brian Van Orsby on behalf of the appellee, Secretary Collins. The question in this case is not about whether Ms. McCray has friction with her supervisor. She clearly did, but Title VII protects against unlawful discrimination in personnel actions, not supervisory friction or workplace dissatisfaction. The district court applied the correct summary judgment standard. It credited Ms. McCray's facts where they were supported by the record. It drew reasonable and not unreasonable inferences in her favor, and still it concluded that the government was entitled to judgment as a matter of law. That's because no reasonable jury on the facts that were presented to the district court as summary judgment could have found in Ms. McCray's favor. There are many reasons why the district court's judgment should be affirmed, but I'd like to focus my presentation on 3 of those reasons subject to the court's questions. First,
well, since you gave us an opening for questions, Ms. Randall says that there's deposition testimony that white nurses were treated differently and better than black nurses. Was there specific testimony in the deposition to that effect?
No, Your Honor, that would not be accurate. In fact, I did look through the record. I did locate in Ms. McCray's deposition where she specifically testified that Ms. Duda did recommend disciplinary action for Caucasian employees. There was nothing in the record to suggest that the discipline was then retracted, or it was only made to suggest that McCray was coming down hard on the Caucasian nurses. And in fact, there's also deposition testimony specifically from Ms. McCray that Ms. Duda targeted Caucasian employees personally with hostile work environments. I believe one of the situations was Ms. Duda allegedly went to a Caucasian employee under her command in public and told her that she wasn't smart enough and that she should probably look for a new job. That's not great, but that's not discrimination. And in fact, that directly undercuts Ms. McCray's claim or allegation that there was racial animus on the part of Ms. Duda.
What is your understanding of the best evidence in support of on the discrimination claim that supports an inference here? What would be the best evidence in your view? And it's kind of an unfair question, but I'm trying to focus us on what the record actually shows.
The best evidence, Your Honor, I think would be Ms. McCray's allegation that Ms. Duda, a year after she left her employment, made a statement to another African-American employee that, quote, she liked her headscarf, that she never understood why Tanisha Burks, who's another African-American employee, referred to as an Aunt Jemima scarf. But I still, that being the best evidence is not great for Ms. McCray, because what the case law says in the 10th Circuit is that statements by another employee that have a racial undertone don't reflect racial animus by the decision maker in this case. And in fact, especially on the facts here where Ms. Duda says, I didn't understand that term to be have racial connotations. And in fact, I was in the middle of trying to provide this employee with a compliment. It doesn't reflect any racial animus. And that is one of the points I want to talk about with the court.
Where in the appendix of the record do we find that, the Aunt Jemima reference? Do you know?
Your Honor, just give me a moment. I can pull it up.
But it is in the appendix?
It is I have it in the supplemental appendix. It is starting at page 1652. It's volume 7 of the supplemental appendix. And you'll see it.
And whose deposition is that?
It's not from a deposition, Your Honor. It's a compendium of documents that Ms. McCray attached to her summary judgment response. Your Honor, there was only there was 2 depositions taken in this case, one being Ms. McCray, the second being the facility director at the time. That the deposition of the facility director was not used in summary judgment, so it's not in the record. So the only deposition that the court has to look at is Ms. McCray's deposition. Your Honor. There's other depositions from Ms. Dial's case that were attached to.
What about Mr. Cummings, Dr. Cummings? Is his deposition in the record?
Dr. Cummings' deposition was taken in Ms. Dial's case. It wasn't taken in this case, so there wouldn't be any information specifically as to Ms. McCray necessarily and her claims. But
So
I
it's
do.
not in this appendix.
It is in this appendix. That's correct.
Okay.
It was taken in another case, but used in summary judgment in this case.
I understand. Thank you.
Just to get back to some of the points I want to talk about, because there is a very, I think, important point for this court to consider, which is what is the appropriate standard for a federal employee to prove a claim for discrimination under Title VII. As we know, Ms. McCray is a federal employee, and under the federal sector provisions of Title VII, a federal employee must show that she suffered a personnel action in order to be successful. And uncontroverted facts do not support that there is a personnel action in this case. Title VII of the federal sector provision of Title VII provides that all personnel actions shall be free from discrimination based on race. And the Supreme Court recently in BAB recognized that that term has a very specific and, quote, easy to understand meaning under the Civil Service Reform Act. That's Section 5 U.S.C. 2302. A personnel action is a specific list of enumerated actions or would fall into a catch-all, any other significant changes in duties, responsibilities, or working conditions. We don't have that in this case. For example, Ms. McCray complains about being yelled at. That's not a personnel action. Countermanding instructions given by a subordinate is not a personnel action. Holding a coaching session with a mentor is not a personnel action.
What about the question of inadequate training?
Yes, Your Honor, that's one good point that we were going to get to. So under the statute, Section 5 U.S.C. 2302, there's a specific enumerated action for training, for a decision concerning training if that decision might reasonably lead to another listed personnel action. It's important here to pause for a moment to take stock of what exactly is the decision at issue in this case. Ms. McCray, when she initially initiated this lawsuit, alleged that she was denied nurse manager training, but she did have to admit during her deposition that she actually was provided that training. And so the allegation shifted. Now she claims that the training was inadequate. And how was it inadequate? Ms. McCray alleges that she was given training by Ms. Duda, where it was a session where she showed her how to do the certain actions, the particular actions. Essentially, what she says is pointed and clicked and said, this is how you do it. From the government's perspective, that's not the type of decision concerning training that might lead to a personnel action. A decision regarding the length or the specific content of the training is not that type of decision.
That sounds to me like a fact question, not a legal question, and it should not be resolved in summary judgment.
Your Honor, I don't think it's a fact question because the facts were uncontroverted. No one disagreed about how the training went down. So I don't think it's a fact question for a jury to decide. The court can decide in the first instance whether or not that particular action qualifies as a personnel action. It's a legal question from the government's perspective.
And counsel, what is the applicable law that we should look to determine what constitutes a personnel action for the federal sector provision?
If I'm understanding the question correctly, from the government's perspective, the applicable law to determine whether or not there's been a personnel action is Section 5 U.S.C. 2302, which defines personnel action. But I will say, Your Honor, if the court proceeds to the catch-all, significant change in duties, responsibilities, or other working conditions, the court can fall back to its prior precedent because, of course, this court has for many years considered whether or not an adverse employment action had occurred, as the question was whether or not that was a significant change in the working conditions. And so the court can fall back to that prior precedent to determine whether or not there's been a personnel action under the catch-all.
Would that require more factual investigation? I mean, whether something falls under the catch-all?
I don't think so, and especially in this case, Your Honor, because the facts really were uncontroverted. The government, in its motion for summary judgment, primarily relied on Ms. McCray's own testimony to support his motion for summary judgment. And I will note, and I think this problem occurred both at summary judgment, I think in the briefing here, all of the facts that are presented to this court and Ms. McCray's appellate brief come from the pretrial order. I won't say all, the majority of them. And I think that's pretty telling because what the court doesn't have in those allegations in the pretrial order is citations to the record to support that fact. And that was also an issue at summary judgment where the fact would say one thing and the citation, you look in the record, it says something different. And so part of the issue, I think, with Ms. McCray's response in summary judgment and why the district court concluded what it did was that many of the facts presented by Ms. McCray simply did not have support in the record. And of course, under Rule 56 and the summary judgment standard, when those facts don't have support, the court doesn't have to credit them. I want to shift gears.
Can I ask I'm just trying to understand what's before us on appeal. You heard me ask Ms. Randalls about the hostile work environment constructive discharge claims, and she conceded constructive discharge has not been appealed, but she said that the hostile work environment, the second claim, was properly appealed. And that was that claim, as I understand it, was resolved on the pleadings. I read your response brief to disagree with that. And in fact, it's just by a footnote. In other words, you kind of see it as a gimme that she's not arguing. And that seems to matter here to me because the hostile work environment has a separate doctrine of continuing violations. But what's your view of that?
Yes, Judge Federico, that's absolutely correct. We don't believe that the hostile work environment claim has been appealed at all. If at most, Ms. McCray's brief has a sentence, one single sentence saying the hostile work environment claim shouldn't have been dismissed, and that's obviously not enough to put that issue before this court. One other thing I do want to mention on that note is Ms. McCray's claim that she has a retaliatory harassment claim. We believe that claim's also been waived. The magistrate judge ruled that she had not brought that claim in her district court complaint. She did not appeal that decision by the magistrate judge. And as the district court noted, and the district court noted that in its order, that the issue wasn't before the district court to resolve because there had been no appeal. And so under the firm waiver doctrine, we believe that issue has been waived and is not before this court. And so the only two issues before this court today are Ms. McCray's discrimination claim and her retaliation claim.
Mr. Vandersby, I didn't understand exactly your point on the pretrial order. Are you saying that in the pretrial order, there's no citation in the record, but there are assertions by Ms. McCray in there that have no basis in the actual record? They're just in the pretrial order. Is that correct understanding what you were saying?
So, Your Honor, what I would say is the pretrial order is not the summary judgment record. And so those facts were not before the district court. So those are not things the court considered. But what I think is telling is that the pretrial order is just allegations. It doesn't require any support in the record. That's different from summary judgment.
It doesn't matter anyway because you're telling me the pretrial order is not in the record.
No. I'm sorry, Your Honor. I'm sorry if I was less than clear. The pretrial order is in the record.
Okay.
What I'm saying is that the pretrial order is not the summary judgment record because Rule 56 requires citations to the record to support the allegations.
I understand that. It was the portion of the pretrial order that counsel is referring to in citing it as evidence. Do they come under a title, under a subtitle in the pretrial order of claims and assertions? Or is it in the undisputed facts? Or where is it?
So it's in the allegation portion. The pretrial order doesn't include undisputed facts. It's just to frame the case before the court.
But it's clear that they're denominated allegations and claims.
Yes.
Okay. All right. That's all I want. Thank you.
Yeah. But those allegations are functionally different than what is presented to the court on summary judgment, where we have to have citations to depositions, affidavits, declarations, those types of things. I only have 22 seconds left. I just want to mention my second and third points that the uncontroverted facts do not support an inference discrimination based on race. And that goes to the questions that you were asking my friend on the other side, Judge Murphy. There's nothing in the record to really support that there was any racial animus on the part of Ms. Duda.
Well, Well, other than her testimony, right?
Other than Ms. McCray's unsupported speculation that racial animus must have been the reason for the actions Ms. Duda took. And this court has said many times that that type of evidence is not enough, it's not sufficient to overcome summary judgment. What we need to see is more specific facts, some evidence of discrimination in the actions that Ms. Duda took, and that's just not in this case.
Is it your position that these statements in the deposition are generalities and there is no examples of when there was disparate treatment? Is that fair? Is that what you're saying?
That's fair, and it's important to note that the statements that Ms. McCray relies on from her deposition were actually questions I asked her to read her complaint, say, this is your allegation and your complaint, tell me about that. And so it's important to note that as well, but specifically, there's no specific examples from Ms. McCray in her deposition testimony. And of course, she had a full discovery period to obtain any evidence that she thought she needed to support her case. She did not present that in summary judgment. And just finally, my last point, Ms. McCray has not presented any evidence that from which a reasonable jury could infer that Ms. Duda had knowledge of Ms. McCray's protected activity. And with that, Your Honors, I'd ask that the court follow the record, not the rhetoric, and affirm the district court's opinion. Thank you.
Thank you, counsel. Thank you both for your helpful arguments. Case will be submitted. And I think that concludes our 4 cases for argument this morning. Court will be in recess until tomorrow morning at 9 and counsel are dismissed. Thank you.